Good afternoon. It is about 6 o'clock and we're ready to get started. I'm really pleased to see that there are about 23 people here today. This seminar webinar is on divorce and children and how children are impacted through the divorce process and what the laws are and what parenting plans are and child support. This is intended as a deep dive. And I'm just so happy to see so many people here. My name is Steven Leskin, and I am a divorce attorney in Portland. So the agenda for today is we're going to give a little bit more introduction, and then we'll go through issues like custody. We'll do a deep dive on custody and what that means. We'll get into parenting time and then child support. I don't want to take questions during the seminar. My contact information is available. Take my number, take my email address, and you are welcome to call my office or send me an email, and I'll be certainly happy to speak with you about any questions that come up. I find that questions are either too specific and not helpful for everybody, or just interrupt the flow too much. So I just give me a call. We'll talk about it, and we'll get your questions answered. So again, my name is Steven Leskin. I have been an attorney in Portland since 1992, doing family law here since about 2001, and doing mostly divorce and mediation since about 3-4 years now, and building that part of my practice. You can find me online by searching Steven Leskin or leskinlaw.com. The business name is One Day Divorce Mediation. You can put that in your Google browser and search that, and I should come up pretty close to the top. So let's get into it. The first thing we're going to talk about is custody. And the first question comes up is, what is custody? So what I tell people and where I like to start is that custody does not mean what it normally means, and it doesn't mean what it means in a legal context here. So when we say custody, that means like possession. Like I have custody of my car, I have custody of a bank account. A person is in custody means that they're in jail. But custody in terms of divorcing family or between parents who aren't married, custody means a court order giving one parent or the other, or joint custody, the right, the exclusive right to make decisions over their child's life, right? And the decision making covers education, it covers medical, it covers religion. And so all of the big issues can be decided by the person who has custody. So custody is a court order, which means, do parents who aren't getting a divorce or living together, do they have custody? And the answer to that is no. Sure, they have possession of the child, and in that sense, there's custody, but they both have equal decision-making rights about the kid, but there's no custody until the court enters a custody order. And so that has all kinds of implications. For example, either parent could take a child across state line, or take a child, not necessarily internationally, there are other restrictions, but could take the child anywhere in the country, or can enroll the child in whatever type of program or educational program or religious program they would like. Without a custody order, when parents are together, they are presumed to make joint decisions in the best interest of the child together. And neither parent by law has more power or control over the other. So custody is a legal concept, and it becomes an order that's granted or imposed, depending on your point of view, by the court. It's just a legal contact. It's just a legal construct. And the only way you get there is by filing a petition for custody in the case of unwed parents, or a petition for dissolution in a married context. So let's take a little step back, even though we just got going, and ask, what are parents' obligations to their children? So this is intended as a little bit deeper dive than just a typical seminar. And so I wanted to explore some things that normally wouldn't be discussed. And this is where I wanted to start with: what are parents' obligation to their kids? And there's not a lot in Oregon law that lays out what a parent's obligations are to their children. I'm going to quote the law now from ORS, the Oregon Revised Statute 109010. I'm quoting now from memory, if you believe that. Parents are bound to maintain their children who are poor and unable to work to maintain themselves. And then it goes on, and children are bound to maintain their parents in like circumstance. So the only requirement under Oregon law is that parents are bound to maintain their children who are poor and unable to maintain themselves. So Oregon law does not set out an affirmative benchmark for what uh, care or what level of support is mandatory. Uh, it's saying that for children who are poor and unable to maintain themselves, parents have that responsibility. The thing that's interesting about 109010, what I just quoted, is you'll note that it doesn't say minor children. So children could be any age, right? It could be an adult child, and a parent would still have the responsibility to support a poor or unable to work, disabled child. Uh, in a second, we're going to talk about the flip side of that, and we'll come back to that in just a second. The other thing that parents are obligated to under Oregon law, under the ORS, it's ORS 109012, is the expenses of a minor child. And expenses of a minor child fall equally on either parent. So a creditor can seek payment incurred on behalf of a child from either parent, and the parent could be sued jointly or separately to cover expenses, funeral expenses for a minor child, or for really for any expense that benefits a minor child. These discussions apply both to married couples and not married couples with children. The next thing we're going to talk about, and we'll come back to, is joint custody versus custody. So joint custody is what it sounds like. Both parents have equal say in the decisions affecting the children. And so that reflects the biologic, obviously, it reflects the biologic reality that both parents, presumably, contributed to the child, and decision making should be apportioned directly. Oregon law provides that a court cannot impose joint custody. That means that both parties need to agree to it. So the parties can agree to mom having custody, the parties can agree to dad having custody. They can agree that there will be joint custody, but a court cannot by law impose joint custody on a couple that doesn't want to have joint custody. A court can impose custody on a mother or a father. Impose might be the wrong word. Can grant custody to a mother or a father, but it can't impose joint custody on both parents. So let's come back to the question: what does it mean to have legal custody? Legal custody only means the right to make decisions, right? It doesn't talk to parenting time, which we'll get to. It doesn't talk to where a child will reside. It just means decision making, and decision making may be part of where a child resides, but legal custody refers to the right to make a decision. A few moments ago, we talked about the really vague notions of support that are found in Oregon law, that the statute just says support of a child, and there's no benchmark or minimum level of support that's mandated. On the flip side, what Oregon law does is that it criminalizes bad behavior. So it's not setting a benchmark for positive behavior, but it is setting a benchmark for bad behavior. And some of the statutes that particularly impact care and custody of minor children are a failure to pay ordered child support. Abandoning a child is another example of the benchmarks for bad behavior, child neglect, and custodial interference. Child neglect, um, child neglect uh, uh, is pretty much what it sounds like. Leaving a child in a car, having a child in the presence of drugs, um, letting a child get out of a house. These are all things that would constitute child neglect. The penalties for child neglect go up, particularly if a child is in an environment with drug manufacturing or drugs distributions or some kind of more dangerous situation. Custodial interference can only take place when there's a custody order. So a parent who takes their child across state lines um, and doesn't bring the child home cannot be prosecuted as a criminal offense for custodial interference if there is no court order granting the other parent custody. The other thing I would say, and it comes up in questioning sometimes, is supposing one parent takes a child across state lines without the other child's permission, and there's no court order, is that kidnapping? And the answer to that is no. You cannot kidnap a relative. Uh, um, and it's probably for the better that I don't say anything else about that. Custody applies differently to adoptive and step parents. Uh, Rights of adoptive parents are the same as rights of biologic parents, right? So there's no difference in once the child is adopted, it has the full um, rights of a naturally born child. On the other hand, step parents have no rights to a child, to enforcing a parenting plan that they're not part of. So if there's a commingled family with stepkids and step-parents on both sides, the step-parents don't have any rights in the divorce to the other child. There is a remedy to that. Of course, step-parents develop deep, caring, loving relationship with their stepkids, and a step-parent can go to court and get an order, and may be part of the divorce decree that the step-parent maintain certain parental rights, like parenting time with a stepchild with whom they have an emotional attachment. A topic that also comes up a lot is what are the rights of non-custodial parents? So you go to court and you say, I should have custody, and your spouse says, no, I should have custody. So there's a fight, and the judge sides with mom, and mom gets custody. What's dad's rights as the non-custodial parent? And this is actually a very um, uh, confounding issue to me, and I can get into that. But um, Oregon law, the Oregon Revised Statute, lays out what the rights are of a non-custodial parent, and they are they are all uniformly information rights. So, for example, a non-custodial parent has the right to school and education records, and has the right to communicate with school staff to the same extent that a custodial parent may, and can receive the same records, same results, and consult with staff. Uh, so you can see where that gets into a problem immediately with, well, staff says child's acting out, custodial parent wants the child to stay in school, or some scenario, and theoretically the rights of the custodial parent is only to make is only to receive information, not to make decisions. Another right that a non-custodial parent has is to receive government records and law enforcement records concerning the child to the same extent that a custodial parent has the right to such records. Um, a non-custodial parent also has the right to medical information, dental information, psychological records, also to the same extent. And again, you see this same issue with supposing a child is in therapy, and the therapist has recommendations, but the on how to proceed with therapy. The non-custodial parent under Oregon law doesn't have the right to make that input. And then finally, a non-custodial parent, and kind of commonsensically, and you would hope, does have the right to authorize emergency care when the custodial parent is unavailable. So certainly, if it's an emergency and a decision needs to be made, then the the non-custodial parent has that right under Oregon law. So the way that lawyers deal with this and the way to negotiate this in a mediation uh, is say, okay, so there's certain things uh, uh, that are important to the couple. So, for example, like education. So a couple may say, well, mom gets, or let's switch up a little bit, dad gets custody, but dad needs to consult with mom and they need to come to agreement on all matters concerning education of the children. So you can write in specific um, cutouts, carve outs for in custody where there needs to be joint decision making. And that is not uncommon. And such things would be religion or medical, particularly if a child has medical issues, where both parents want to stay involved and want to share the decision making. And oftentimes, um, people getting divorced, they still work well. They can still work well with their partner over the kids. Maybe everything else is falling apart, but they still parent well together. And those kinds of carve outs for custody are certainly appropriate in those circumstances. Oops. So how does a court decide who gets custody? So let's say it's a unwed couple, and um, dad has been raising the child. The child has been staying with dad, and mom sees the child sporadically. How would a court go ahead and make a decision over who should get custody in that circumstance? Oregon law lays out very explicitly the factors that a court needs to consider in making a custody decision. So, for example, um, the court needs to make its decision in the best interest and welfare of the child. And in making that decision, the court is obligated to weigh 6 or 7 factors, and each of those factors are to be given roughly equal weight. There's one that predominates, and I'll get to that in just a second. So the first factor that the court has to consider by law is emotional ties, and I'm quoting now from the statute, the emotional ties between the child and other family members. So this looks to how a child interacts with both sets of with both parents and with other family members, maybe with siblings, maybe with aunts and uncles, nephews, and where is that? Where are those relationships richest for the child? The second criteria is best interest. I misspoke. The interests of the parties in an attitude towards the child. So oftentimes one parent will show more interest in a child, will be more committed to the child's welfare, will be more committed to the child's development, and the court will take evidence about that, and the parties' attitude towards the children. So, for example, I read this to explain what kinds of things do the parents teach? What kinds of things do they want their children? How do they want their children to grow up? Are they working towards teaching their kids life skills? Are they teaching their kids their values. So for me, when I address this question in court, I want a parent to come in and say, this is what I'm doing to prepare my child for adulthood or adolescence. Um, or you could say, I don't, there's no value in this, there's no value judgment in this. I believe that my child should have a carefree, unencumbered childhood and should have every moment lived richly and fully until they're 18. So, uh, that's an attitude towards a child, and the court's going to take uh, um, weigh that against the parties' attitudes, not necessarily with a value judgment again about lifestyle, but about how they're relating and preparing their child and what they're doing to keep just to maintain, not maintain, but to give the child a good life and prepare the child for the future. And so that's the way I explain that second criteria. The third criteria is the desirability of continuing an existing relationship. I always kind of thought that that was miswritten into the law. I think it should be relationships, um, but it's singular, so presumably that's talking about the other parent. But I read it to mean existing relationships with family members, with friends, and with professionals in the environment. So, for example, uh, the parents' attitude in keeping the children's existing relationships strong and ongoing, and the court will want to see evidence of that. Uh, then the court switches a little bit and looks to the parents' relationship to one another. The court will consider whether or not there's abuse by one parent or the other, and uh, in this context, abuse isn't really given the same kind of definition that it comes up in elsewhere in Oregon law. But evidence of abuse, particularly evidence of documented violence, uh, um, will help sway the court one way or the other with who should get custody. And then the last and most significant factor is who's been the child's primary caregiver. In this scenario that I started out with, where dad had uh, the child was with dad and mom was only around sporadically, uh, the preference will go to dad because the dad has been the primary caregiver. That just comports with common sense generally. Oops, going backwards. So let's talk about the custody battle. And uh, custody cases are oftentimes the hardest, particularly if there are two competent, loving parents who just they can't parent well together. They're not a good family anymore, but they both have um, resources to provide the kids. And by that, I don't mean wealth. I mean the diversity of resources that are available. And um, uh, uh, they just they can't do it, and it turns into a custody battle. So uh, one of the questions that will come up is, can a child testify in court? And the answer to that is that there are three ways, three options to have a child's voice heard in court. The first is through a private meeting with the judge. A young child can meet privately with the judge, and the judge is obligated to disclose what the child said in a general way, and that is often usually held outside the presence of the attorneys. The second way is that if the child requests an attorney, I found it very rare that a 13-year-old would read Oregon law and know that, but if the child requests an attorney, then the court is obligated, it's mandatory for the court to appoint an attorney at the parent's expense. There are very few, if any, pro bono attorneys for children. So if the court asks attorney to step up, the attorney is responsible to get paid from the parents. And then the third way, so you got child testifying in private to the judge, uh, child having an attorney, and then the third way is through a third party custody evaluator who can give testimony about the child's needs and where what the best custody situation might be. To prepare for a custody fight, there are a couple of things that a parent can do. One is they can keep a log, and the log should correspond to the custody factors that we just talked about. So, for example, interest uh, the interest and attitude in kids. Keep a log with dates and descriptions, and make them contemporaneous, but for each of the factors. So you can give examples when you come to court of uh, the child's um, existing relationships. Like, I'm taking the child to the doctor. I'm going to the one who's going to all the PTA meetings. So you want to keep a log of all of the factors that you want to be able to testify, and you want to keep that log over time. And it will become hard to remember, particularly in a stressful situation. But keeping a log will help do that. I recommend just creating a table in a Word Perfect doc or Word document, and just formatting it with, date, situation, description, and then factor. And then you can also put in, if you have photographic or video or audio evidence, you can do a link to that. And that way, when you come to court, you'll be really well organized. Take lots of photographs of the children at family events, and the children engaging in activities. And particularly helpful is parents interacting with their children, teaching them things. So, for example, maybe you play the piano, teacher, photographs of you teaching the child piano, photographs of things like going sailing or going hiking. Uh, those type of activities help teach children life events and life skills. And so photographing those kinds of things with an explanation, when I take my child backpacking, I want my child to learn how to be self-sufficient. I want to teach my child how to be prepared. I want to teach my child how to anticipate, right? And that's the interest and attitude in the children that you want to be able to document and testify to when you get to court. Lastly, remember that all of your communications with your ex or with the other parent may ultimately be read by a judge. So you want to always keep in the back of your mind that your communication, which you are assuming is private, may not be private, and it may be read in court. And you're flying off the handle, your threats, your not very well considered words may be used against you, and may ultimately be read by a judge. So always keep in mind that whatever's going on, if you're in court, whatever's going on between you and your spouse, very well may not stay private. So you've gone to court. The court has awarded custody to one parent or the other, and it's a couple years later. And supposing it was mom who got custody, and mom has been having a really hard time since the divorce. Mom's mental health was good at the time of the divorce, but mom is falling into depression. Mom is drinking a lot. Mom is not holding steady jobs. Mom's falling asleep before making dinner. Can you modify a custody order so that dad now has custody? And the answer to that is yes. So there has to be some showing of unanticipated change, and a change of circumstance, an unanticipated significant change of circumstance at the time of the judgment. And the change that you want to see imposed has to be in the best interest of the child. So in this scenario that I just threw down, clearly it's going to be in the child's best interest to have a non drinking, mentally healthy parent, which would be the father. So father could go to court and say, there's been a change of circumstance. Mom's mental health has declined precipitously, and it's no longer in the best interest for mom to have custody, but it is in the best interest for dad to have custody. So that's how you'd go about modifying a custody order. And just to make it clear, the custody order will be found in the general judgment of dissolution if there's a marriage, or in the judgment of custody if there is no marriage. Both of those are two separate documents, and both of those documents, depending on the marital situation, will contain the custody order. Oops, sorry about that. So we've been talking at length about essentially about decision making and custody and how custody is awarded, what the courts look for, how to get custody, how to modify a custody order. We're going to talk about the flip side of custody now, which is uh, the parenting plan. The parenting plan is what allocates the child's time between the two parents. Uh, and uh, a parenting plan can be as detailed as necessary or not. And a parenting plan ultimately may be just ignored by both parties if they're getting along well and the aggravation and trauma that caused the divorce is no longer present. So the first thing to know about parenting plans is that they're there when there's disagreement. If the parents are agreeing on everything, then there's no reason for a parenting plan. If both parents agree that the parenting plan isn't working and they really don't feel that they need another one, fine, nobody cares. On the other hand, if one parent is not returning a child uh, to the other parent or is uh, smoking or drinking in front of the child, and that's prohibited under the parenting plan, uh, the other parent has the right to go to court to enforce the parenting plan. So policy of the state of Oregon is that both parents, barring exceptional circumstances, should have a relationship with the child. And the courts take that very seriously. The courts do not diminish parenting time and certainly not parenting rights without a strong without strong evidence that they should. And the parenting plan is what embodies this principle. I write here that the parenting plan is the rule book, and it is. And you want to set up a parenting plan so that it's clear and enforceable. You know that if a parenting plan says that um, the child, one parent lives on the East Coast, the other on the West Coast, and the child's going to travel back and forth. If the parenting plan provides that an adult will always travel with the child, that's the rule. You have the right to go to court to enforce that rule or not put the child on the plane. So it becomes the rule book for parents who are still not parenting well together. A parenting plan provides parenting time to both parents. And what I would note is that a parenting plan also provides downtime to the parent who has the child or children the majority of the time. I've known many, many single women who have their children all the time, and it is constant and a constant drain. And an occasional break from that is always welcome, or I should say, is many times very, very welcome. And um, it's just a basic consideration that that be observed. Uh, there are samples of parenting plans online that are very good. The Oregon Judicial Department, not the courts, but the Oregon Judicial Department, uh, through a state committee on family law, uh, puts up family uh, puts up parenting plans for different age groups and also for considering safety situations. And so a person could find a parenting plan um, at the Oregon Judicial Department website and modify one of those plans for themselves. You can also bring, if you're going to go to court mandated mediation, you can bring a parenting plan with you. And the goal of the mediation is to fill out the parenting plan in a way that works for both parents. The parenting plan is enforced by the parents, not by the children. The children do not get a say. So if the young daughter is screaming that she doesn't want to go to daddy, uh, it's daddy's right to spend time with the child too. So absent safety considerations, the child really, until the child gets older, 14, 15, the child really doesn't have a lot to say. It's a negotiated plan between the parents and not the kids. And then finally, something to keep in mind is that the number of overnights that are in the parenting plan go into determining child support. It's going the wrong way yet again. We talked about modifying a custody order. We'll also talk about modifying a parenting plan. Unlike a custody order that can only be changed in the presence of a significant unanticipated circumstance, that's not necessary for a parenting plan. A parenting plan can be modified on a showing of best interest of the child. So um, if the parents can't agree and they go to court, they don't have to prove change of circumstance, only that uh, the best interest of the child would be better served by a modification of the parenting plan. Parents can go through court mandated mediation, they can go through private mediation, they can agree on their own to modifying the parenting plan. If they do, Oregon law provides that the modified parenting plan should be filed with the court. Just write it up and file it with the court. If you can't agree and you've gone through mediation and you've gone through private mediation, your only option then is to take the case to court and let a judge decide. Um, and the court will note that as children age, it's more appropriate that they get more time, they get more say in the parenting plan. And as they age, it's also appropriate to modify a parenting plan. So parenting plans aren't anticipated to be static documents. They're certainly going to change as circumstances change, as children change, and that's just an anticipated um, part of a parenting plan. So next question is, what should be in a parenting plan? So the parenting plan will talk about which parent gets children at which points in time, weekends, holidays, things like that. We all know the standard parenting plan. Dad gets child every other weekend, Wednesday nights, and then Christmas and New Year's on even years, and vice versa for mom. So like that's just the general outline of the parenting plan. Other considerations are there safety issues for kids? So I divide this into two things. Are there threats of harm, like a parent driving drunk? That is a safety consideration, and ways to deal with that are there are uh, devices you can buy. I'm just momentarily blanking on the names, but there are devices you can buy that will tell the other parent whether or not a parent has been drinking, and if it returns a positive, then the parent forfeits parenting time. There are if there are threats not to return a child, or drug use, or a lot of people in and out of the house, or things along those lines where there are safety issues, then it might be appropriate to appoint a parenting supervisor when the offending parent has time with the kids. Um, so I differentiate between safety issues and adverse behavior. And to me, adverse behavior is smoking, drinking, drug use, promiscuity by either parent in the presence of the kids. And that can be addressed in a parenting plan and then enforced by the court upon a showing of appropriate evidence. So, for example, the parenting plan could say, mom won't smoke in the house. Um, Mom won't smoke in the house when the children are there, or not for a couple hours before. Mom or dad won't drink for hours before he has parenting time, or during parenting time, and that's monitored, uh, as opposed to like driving with the kids in the car. Or maybe the drinking is not excessive, but it's still troublesome to one of the parents. You can deal with those type of issues directly and expressly in the parenting plan. Um, Addressing problematic conduct between the spouses, that can also be addressed in a parenting plan. It's common to have a non-disparagement clause, meaning that neither of the parents will say bad things about the other in the presence of the child or children. Uh, a problematic Other problematic areas may be new boyfriends, new girlfriends, and not bringing them around until a certain point in time. International travel is another, problematic area. So all of these are things that can be addressed and should be addressed in a parenting plan. Enforcing the parenting plan. There is an expedited procedure under Oregon law that requires a parenting time enforcement action to be held within 45 days. Courts have a huge amount of discretion on how to enforce a parenting plan. It could be modifying the parenting plan. It could be taking custody away. It could be imposing supervised visitation. Court has wide discretion in how to enforce the parenting plan. Most courts nowadays have a family resource center that can help a parent pick out the right forms. They won't necessarily help you fill out the form, but they'll get you to the right place and tell you how to file it and get the court date. You may be required to mediate before going through a court process pursuant to the local rules. So those are some things to keep in mind when enforcing a parenting plan. Oops. Okay, last one. Last big issue is child support. Child support and spousal support are two very different things. And it's important to understand this. Spousal support only applies, what I should say is spousal support is a negotiated amount between divorcing parties, between a divorcing couple. It's a negotiated amount. Both the amount and the duration of spousal support are negotiated. The Oregon law gives some guidelines about when and under what circumstances certain spousal support should be awarded, but it doesn't give specifics about how much or how long. On the other hand, child support is set by statute, right? So it's not negotiated. And I would say mercifully that's the case, so that parents aren't, well, I only think that the child should get $400 a month. It's set by statute. And the way that child support is calculated is through a child support calculator. And the child support calculator is found at the Oregon Department of Justice website. You'll see a section called Children, and the child support calculator is found under that heading. And what you do is you put in the income of both parents, you put in the number of overnights that each parent has, you put in the number of children, and there's some other factors, such as whether or not spousal support is paid, whether or not there's federal benefits, union membership, who's paying the health insurance. All of those things are put together, and then the calculator will give a number, and that is generally considered the spousal support, I misspoke, the child support amount that will be awarded by the court. Under just and appropriate circumstances, the court can modify that, but there has to be a specific showing of facts that would justify modifying that. I will give an example. Family had 2 kids and a lot of real estate, and mom took over 7 paid off homes during the divorce. And so child support was clearly just not appropriate. Mom was going to be self-sustaining through the rental income, and that was more than sufficient to cover the child support. So that was a circumstance where it just wasn't appropriate that dad should continue to pay child support. Getting child support, there's 3 ways that you can get child support in the state of Oregon. One is you can set up an account through the Oregon Department of Justice. Through the Oregon Department of Justice, you can go online and you can call in, or I think you can do it. I'm pretty sure you can do it online. You can get the process started online. You can do it through the county district attorneys, or you can file in as part of the divorce or custody action. You will ask the court to award child support. It's mandatory. It's not optional. The court has to deal with child support in its order. In the same way that we talked about enforcing a parenting plan, we're going to talk about enforcement of child support. A child support order can be enforced also through the county district attorney or the Department of Justice. And those 2 entities have a number of options to collect money from a non-paying parent. They can do automatic income withholding, which is wage garnishment. They can take wages from a paycheck. They can suspend professional licenses. The district attorney of the state of Oregon can seize bank accounts, put liens on real property. They can intercept federal and state tax refunds, and they can suspend a driver's license. So those are some pretty powerful tools for collecting child support. Earlier, you'll remember back to the beginning when we said not paying child support is also a crime, and that's true. It's very, very rare to see a person prosecuted solely for non-payment of child support. It's usually in connection with neglect or abandonment of a child. It's usually not a standalone crime. If an individual goes to court and asks for the court to enforce it, the court can issue an order of contempt, which would include fines and attorney fees, possibly under certain circumstances, prison time. A lawyer can seize a bank account and uh, intercept person's wages to collect child support. And same thing, child support can be modified through Department of Justice, through the local district attorney, or through the court. And that's going to be same kind of thinking based on change of circumstance. So somebody who's paying child support, if they lose a job for an extended period of time or become sick and ill and can't make payments, that person could certainly go to court and or the Department of Justice and ask that their child support obligation be reduced. So that's it. There are still plenty of people here I'm happy to see. Please give me a call. I will be happy to answer your questions. My contact information is on the screen. I'll leave it on for a few more moments. And please, thank you for spending this hour with me. And I will look forward to hearing from you. Thank you.